welcome everybody to today's panel discussion on domestic violence in the new COVID normal, opportunities for change and reform. My name is Vanessa Shambrook and I'm the President of Victorian Women Lawyers and lawyer working in family law and family violence at Women's Legal Service Victoria. I begin by acknowledging the traditional custodians of the land on which we meet today. For me, that is the Bunurong and Wurrung peoples, and pay my respects to their elders, past and present. I extend that respect to Aboriginal and Torres Strait Islander people here today. Today's webinar is brought to you by the Justice Committee of Victorian Women Lawyers and Nicholes Family Lawyers. VWL is the peak representative body of female identifying lawyers in Victoria. One of VWL's key objectives is to promote the understanding and support of women's legal and human rights. Nicholes Family Lawyers is a leading specialist provider of family law services based in Melbourne CBD, with clients throughout Australia and internationally. This leads me to introduce our moderator for today's session, Sally Nicholes, who is the founder and managing partner of Nicholes Family Lawyers and has practiced exclusively in family law since 1995 and is recognised within Australia and internationally as a leading family lawyer. So thank you, Sally, the team at Nicholes Family Lawyers, and to our special guests for supporting this very important topic today.
Thank you, Vanessa, and welcome everyone to today's panel discussion on domestic violence in the new COVID normal, opportunities for change and reform. My name is Sally Nicholes and I am the Managing Partner of Nicholes Family Lawyers, and I have the honour of moderating today's discussion. Before I begin, I would like to acknowledge the traditional custodians of the land upon which we meet today and pay respects to their elders, past, present and emerging. I extend that respect to and welcome any Aboriginal and Torres Strait Islander peoples who may be with us today. Thank you, Vanessa, for that lovely introduction, and thank you to Victorian Women Lawyers for their fantastic support, and to all of our event partners for all their incredible work to make today's event possible. Life is slowly returning to normal following the lockdowns we faced throughout last year. However, some of the negative repercussions of the pandemic still remain a prevalent issue in our society. Domestic violence was a significant issue prior to the pandemic, which only worsened throughout the lockdown periods due to several factors such as increased social isolation, loss of employment, close living situations, and decreased access to support services. In some instances, COVID-19 was used as a weapon in family law disputes, with, for example, parents using the fear of COVID-19 as a reason or excuse not to comply with court orders concerning access to children. Coercive control, which is a pattern of controlling behaviours that create an unequal power dynamic in a relationship, became increasingly common in abusive domestic relationships. In today's webinar, we will discuss the concepts of domestic violence and coercive control, as well as the new forms of domestic violence has taken in the new COVID normal era and the opportunities for reform. Coinciding with the domestic violence spike throughout the COVID-19 pandemic is the increased media attention given to the issue. It is vital that our media outlets avoid sensationalising or using headlines to clickbait readers on this subject matter. Instead, the media should employ language that empowers victim survivors and reiterates the need to empower those who have shared their experiences. As such, today, our panellists will consider why the lockdowns caused spikes in domestic violence, the impact still being felt, and what needs to be done going forward in the new COVID normal. We will also focus on how victim survivors and their families can be better supported and prevention strategies and opportunities for law reform concerning domestic violence. With this in mind, today's discussion is vital to closely monitoring the fallout effects of the pandemic, how it had affected the incidents and types of domestic violence occurring within our community, and where change must be made. I have the privilege of being joined today by vital stakeholders in family law and domestic violence support and prevention in Australia. I would especially like to thank the Chief Justice of the Family Court of Australia and the Chief Judge of the Federal Circuit Court of Australia, the Honourable William Alstergren, for joining us today. We are honoured to have the Chief Justice joining us and are very much looking forward to his insights, along with those of all the panellists. Please note that due to court-related commitments, the Chief Justice is unfortunately unable to stay for the duration of the webinar. So I'd like to introduce our panellists formally. We have the Chief Justice, the Honourable Chief Justice William Alstergren, who was appointed as Chief Justice of the Family Court of Australia on the 10th of December 2018. His Honour holds a dual commission as Chief Judge of the Federal Circuit Court of Australia, to which he was appointed on 13 October 2017. His Honour is also the Administrative Head of the Appeal Division of the Family Court of Australia. After graduating from Melbourne University in law and completing an LLM, Chief Justice Alstergren undertook articles in family law with Kenneth Croxford and Co. From 1991, he practiced as a barrister in Melbourne and took silk in 2012. His Honour was regularly briefed in large and complex commercial, family, industrial and tax trials and appeals in the Federal Court and State Superior Courts. He was a member of the Bar Ethics Committee, the founder of the Bar's Pro Bono Duty Barristers Committee, and received the Distinguished Pro Bono Service Award by the Victorian Chief Justice in 2008. His Honour is a former chairman of the Victorian Bar. Immediately prior to coming to the bench, His Honour was the president of the Australian Bar Association. In his spare time, Chief Justice Alstergren enjoys spending time with his family, walking his two kelpies, playing electric guitar, surfing and reading. His Honour enjoys all things Norwegian and supporting the Hawthorn Football Club. We also have the privilege of being joined by Julie Kuhn, CEO of the Women's Information Referral Exchange, WIRE. Julie is a white settler of migrant refugee parentage. Julie is a feminist, social worker and social justice activist. Being able to lead an organisation like WIRE is a privilege that enables Julie to live out her values and hopes for her community in her daily work. WIRE is Victoria's only free support referral and information service dealing with issues for women and gender diverse and non-binary people. We're also privileged to be joined by Louise Sims, Executive Director at Domestic Violence Victoria. Prior to her current role as Executive Director of Policy Communications and Engagement at Domestic Violence Victoria and the Domestic Violence Resource Centre Victoria, Louise has several roles at DVRCV, including Director of Communications and Policy and Advocacy Manager. She's previously worked in policy at No to Violence, the peak body for specialist family violence services, working with perpetrators, and had an extensive communications career in the housing and homelessness sector. Louise has a Master of Public Policy, a Graduate Certificate in Social Science, and a Diploma in Design, 3 disciplines which she is very fortunate to be working at the intersection of. We're also joined by Dr. Adele Murdolo, who is the Executive Director at the Multicultural Centre for Women's Health, a women's health centre run by and for migrant and refugee women. Adele is a second-generation Italian migrant woman with a background in feminist research and advocacy on the topics of violence against women, women's health, feminist history and activism. Adele has a PhD in History and Women's Studies and is an Honorary Senior Research Fellow at the Centre for Health Equity at the University of Melbourne. We are also joined by Helen Matthews, who is Acting Chief Executive Officer at the Women's Legal Service Victoria. Helen has practiced as a family lawyer for over 30 years in private practice for Victoria Legal Aid and has been Principal Lawyer at Women's Legal Service Victoria since 2012. She leads its family violence and family law reform work and oversees the provision of direct client services to women experiencing family violence and disadvantage. These services include representation in complex family law litigation and family dispute resolution. Helen is a family law accredited specialist. Now, I would like to invite our panellists to share their thoughts and expertise on the content of our webinar today. I'll start with the Chief Justice, given your time constraints. Welcome and thank you so much for participating.
Sally.
We witnessed a radical shake-up to the way in which the family courts operated last year. Can you outline, Chief Justice, some of the positive aspects to have arisen from this disruption, particularly concerning dealing with matters involving family violence?
Well, thanks, Sally, and obviously thank you to you and Vanessa. And it's great to be involved in Law Week. It's also great to be on such a great and esteemed panel with Julie, Louise, Adele, and of course my old friend Helen. We witnessed obviously a radical shake-up like everybody else. We were, like most other, I think, courts and institutions, dramatically underwhelmed with intellectual technology at the time. And we obviously had to get up to speed very quickly because, as we all know, face-to-face hearings virtually stopped or did stop, apart from in particularly urgent cases. Having it as a national court, we had to very quickly look to improve, and we consulted and engaged with people operating at the coalface. And I'm delighted to say I've got a fantastic panel of advisors who, as a result of COVID, came into my life, and I've been very grateful to them, including Angela Lynch, whose idea was to start the COVID list, Helen Matthews, Tanya Clark, Haley Foster, Pip Davis and Liz Snell. And I have to say, they have been wonderful in advising me about some of the issues, particularly that women are facing and litigants generally are facing, and the kind of trends we were seeing very early in COVID. We completely transformed the court within 3 weeks to a digital court file and to electronic hearings through Microsoft Teams. The most important person in the court was no longer the Chief Justice or the CEO, it was the person in charge of the IT division. And everybody was reliant upon their digital natives being the associates who were able to work out how we actually use this technology. Not only were judges able and registrars able to conduct hearings within 3 weeks, they're all competing as to who could do it better. So I was absolutely delighted and very proud of their efforts. The benefits really included improving safety for vulnerable parties. The thing that we've been looking for so long is you don't have to come to the courthouse to be heard and get access to justice. And it was very important from that point of view, from a positive point of view, to demonstrate literally as a proof of concept how technology could work. Given the nature of the work of the Family Court and Federal Circuit Court do, we looked at the fact that closing was never an option for us. We're providing a vital service for Australian families, so that when things happen like border closures of supervised access centres and other institutions, which meant that physically you could not actually obey the court orders that have been put in place for the best interest of the child, we were able to do 2 things. One is to let the public know as best we could on various media outlets that we were actually still open and we were available to assist, but also that they had to know that they could actually vary the orders if they wanted to by agreement for that period of time in which it was physically impossible to obey them. Final hearings and urgent hearings and appeals and general case management were conducted electronically by video and by telephone in some cases. We immediately mindful the courts had to provide an essential service. So during that times of crisis, we had to make sure that people actually also were aware of what we were doing. Part of that, of course, looked at the idea of balancing up the government's restrictions in various states and the confusion families were facing, let alone practitioners. That meant we had to coordinate a national effort in relation to education and what was possible. And we literally had a national court that was operating on 4 or 5 different bases across Australia. And it was very good in that regard to be able to have people at the coalface being able to tell us what they were seeing. There was a massive increase, for instance, in urgent applications, but there was a decrease in final order applications. So from that point of view, we had to be very careful as to how we could cope with that. We undertook a big transformation. As I said, the introduction of the COVID-19 list was really a national, full electronically managed list aimed at dealing with urgent family law disputes that were COVID related. The matters in the list were triaged by a dedicated national registrar, or 2 of them actually, in probably what was the world first. Our triage within 72 hours of being provided to us. They were fast-tracked from implementation in the digital court file. We had to do an audit on existing technology and selected appropriate platforms such as Microsoft Teams, and that wasn't an easy decision. I didn't even know what it was before we started COVID. We had to roll out video conferencing facilities to over 100 judges and 40 registrars across 15 national locations, as well as transforming their operations to operating at home if they needed to in certain jurisdictions. We had to release practice directions which provided for simpler methods of filing and the management of court documents. So it was a massive change. I would say that as a consequence of COVID, we will probably keep at least 30% of the work electronically on a rough estimate, in regional areas, and particularly areas where women and vulnerable parties are at risk, and they would benefit from electronic hearings. So I suppose you never waste a good pandemic, and no one is, but we've learnt an enormous amount. I have to say thanks to the profession for their cooperation. It made a massive difference, but also thank you to the people at the coalface who let us know what to expect, because that made a massive difference. It really did. So, and thank you, Helen, in person.
Fabulous. And in addition to the COVID list, which I knew was just a remarkable list that actually gave family lawyers so much assistance with those urgent matters, as you said, that were facing us at the coalface. It was a wonderful initiative. I know there are other projects and initiatives that the Family Court and the Federal Circuit Court have put in place that address issues of family violence in the context of family law. Can you describe a few of those as well, including the Lighthouse?
Sure. Look, we've got, obviously we're doing a lot of work beforehand. I've got a extremely energetic team. We're looking at this, but with Susie O'Neill from the issues of notice of risk in the Lighthouse project. Our CEO, David Pringle, who does an excellent job, and the whole team were looking at how we could, if you like, harmonise and standardise our approaches. One of them was a new notice of risk, because we didn't have the same notice of risk in both courts. We did a lot of consultation with the profession electronically. It probably saved us a lot of time because no one could actually do anything in person. And we were able to produce a harmonised notice of risk and harmonised rules. So harmonised rules, for the first time in 20 years, we now have a working draft of a harmonised rules for both courts. So rather than having two separate case management systems, two separate sets of rules and two sets of forms for two courts that are doing the same thing predominantly, we've now got a harmonised set. They'll go to parliamentary drafters later this month after being widely consulted on, and hopefully the judges will be able to vote to them before the new court starts in probably, I'm guessing, in July. The Lighthouse project is in 3 different registries. That's showing an enormous amount of promise. We're hoping to roll that out nationally. For risk assessment, that makes a massive difference, and we do hope that we can demonstrate as a proof of concept electronically as well as in person. That does make a massive difference, and it also demonstrates the great worth of registrars in the Federal Circuit Court as well as the Family Court. The small claims property list, the PPP 500, is having a massive difference. Registrars are dealing with that before it goes to a judge, and only over 75% are settling very early, saving the clients a lot of money and also an enormous amount of stress, particularly in family violence cases, where we can actually put these perspective and try and not have property cases being used as a tool to try and put more stress upon people, particularly when they're facing domestic violence. Co-location of police and department facilities are going very well across the country. I still haven't got a Victorian policeman in the Victorian registry yet, but I'm working on that. And then obviously the COVID-19 list. We're also underpinning all family violence related initiatives with the court's family violence best practice principles and our family violence plan. And we're training judges, and we've made an announcement about that. There's been a massive deal of, we've got an ongoing training of judges. We've had world experts coming in, and it's really working very well to make sure that we engage the Safe and Together Institute from the United States to deliver a court-wide training base on Safe and Together model, which is described, I think, as by one of the most leading experts, David Mandel, as being very worthwhile, and that's having a great impact. So we're trying to be as progressive as we can, and it's working very well.
Well, it's interesting you've practically answered this question in such a positive way in terms of what the work that's going on. But I wanted just to comment on the significant media coverage that has been sometimes negative relating to the government's legislative reforms to amalgamate the Family Court of Australia and the Federal Circuit Court. And some of the courage has implied that the reforms will lead to a lack of specialisation in family law and skills in family violence. And having spelt out just a number of your projects, you've already sort of addressed the issue that there are reforms going on. But is there anything else that you'd like to respond to?
Sure. No, thanks, Lee. I mean, look, there's a lot of white noise that goes on in family law. I think it's probably one of the most political areas of the law you can imagine, and has been probably since the court started. There is no lack of specialisation. We had 50 specialist judges doing nothing else but family law in the Federal Circuit Court. A lot of those people were former registrars, former solicitors, former silks at the bar, who doing an amazing job, and they've got an appeal rate of under 1%. So the idea that somehow there's a lack of specialisation because of if you like, the proposed merger is absolute nonsense. And it is, we've indicated by the people that are coming into the court, we'll probably have 26 new judges in the court, including 10 extra judges. And I can assure you that anybody that's being replaced is being replaced by people who are specialists in family law or in a chosen field, but with training in family law. And they are doing a fantastic job. And as they have been, the Federal Circuit Court was doing 88% of all family law work before these reforms, including 92% of all parenting. So the idea there's a lack of specialisation is absolute nonsense. But I have to say, with the injection of the budget, which provided over $100 million of additional resources to be introduced, that's a wonderful opportunity for us to increase our resources, particularly in specialisation of family law. It means that we are also getting more judges in family law itself in the family court as well as the Federal Circuit Court. The number of judges in the Federal Circuit Court will increase from 66 effectively originally to 68 as it is now. That'll be 76 by the end of the year. And the number of Federal Family Court judges will be up to actually 35. So we actually will have over 111 judges nationally, which is over a 10% increase. We've also got over 100 people coming into the court from extra resources, including, as I've said, an enormous amount of registrars who will be specially trained in family law. So no one should expect that anything else but good things will happen in the court. We've got more resources, and specialisation is not an issue.
Yeah, and finally, and it's so exciting about the additional budget. It's such a great signal for the support of the court and these projects. How will the amalgamated court operate, and when will it all commence?
So it commences it gets royal assent on the 1st of September this year. And what will happen is prior to that, there will be a harmonised set of rules, forms and case management systems for it. We'll have a new website. There will be only one place you can issue. You'll be issuing through Division 2 or the Federal Circuit Court. And we will be triaging the cases immediately, which will include risk identification very early in the proceeding, and then specialist treatment of those cases which are high risk, as well as with medium and low risk cases, dealing with those in a much more nationalised and standard way. What we're trying to do is to ensure that there is a safer and world-leading system for litigants to operate by, identify risk very early through Lighthouse, the use of alternate dispute resolution, and also the new notice of risk, reduce delays through call-overs and early ADR, as well as making sure that we're looking at proportioning our resources in appropriate stages in the proceeding, and reducing costs. Basically, we're getting a lot of registrars in, as well as other people, to help judges help the litigants. What that means in closing is that we basically will be trying to, instead of doing between 58 and 62% of the work in 12 months and having those cases either heard or settled, we'll be doing 90%. And I can assure you that for practitioners, it's a fantastic thing because they'll get just as many events, but in a shorter period of time. There'll be more accountability, but there won't be an acceptance of delay or breach of court orders. We'll be very firm on making sure we proceed with this because the people in Australia will finally get the system they deserve. They haven't got it now.
Oh, the funding is great news, and the projects and work that you've outlined is just music to all our ears who practice in the jurisdiction. Thank you again, Chief Justice, for your time. I know you might have to disappear shortly, but I want to join all of the panellists in thanking you again for your generosity of your time.
Take care.
Now, Julie, calling from Wire. Wire recently released a conversation toolkit and videos around having respectful financial conversations. Did the experience of COVID add to your understanding of respectful financial relationships?
It reinforced a lot of our thinking, and that is, it's really important to have these money conversations early and talk things through, and especially talk through assumptions. When things go wrong, like losing a job, it is good to be able to have a built history of having respectful financial conversations, and that will really help a couple navigate the best way forwards for themselves and their families. And because changes in a financial situation can really increase financially abusive behaviour and make existing abusive behaviour more obvious. So I'll give an example. One of the videos that we did was about a conversation about what would happen within with a couple when one was pregnant and was looking at maybe caring for a child. And what we know what happens now is gendered assumptions, even when there's no financial abuse, gendered assumptions of who will do the caring, the value of that unpaid caring work, and who controls the money and makes those financial decisions creep into those conversations. So by having respectful financial relationships, it is about unpacking all those sort of things, because and it's so important, because disconnection from paid work, and we saw in COVID a lot of people being disconnected from paid work. That is a time when we really see that financial abuse intensifies, or because there's less of a buffer, it becomes far more obvious to the person being abused and those around them.
Oh, thanks, Julie. And that, again, a really important topic that could be a seminar, a webinar in itself, I believe, looking at that. Wire also recently released a report titled Too Visible, Not Yet Fully Seen, Insights from the COVID-19 Financial Capability and Intersectionality. What did Wire learn about family violence in the process of writing this report?
Yeah, we learned a lot. We learned a lot, and again, there was a lot of reinforced learning about how systems impact people that are experiencing marginalisation. So we talked a lot to international students, to new migrants, and people that were on all sorts of temporary visas. And there's 1.1 million people in Australia in that position. So they had no access to JobKeeper or JobSeeker, not even access to Medicare. And they were often the first to lose their jobs during COVID, with no financial buffer, with many not having any family supports around them. They not only were in financial jeopardy, but their mental health was also in jeopardy. And we were really amazed by the resilience and the strength and the ingenuity to survive and support each other, which was amazing. But it is such a hurdle to have to overcome. And then you add family violence into the mix, with the government sending clear messages that migrants, temporary visa holders, weren't worthy of a safety net, weren't worthy or deserving of getting basic supports, which most Australians take the standard for granted. And you think, what does this do to a psyche of a person who is experiencing abuse? It sends that message that there is no support, and maybe they're deserving of what is happening to them, or that no one cares anyway. It really sent that, and that's one of the things we kept on hearing. We felt that not only the government didn't care, but people in the community didn't care. The other thing you need to think about is the access to the other services. So there are a lot of temporary visa holders that don't have access to refuge, to family violence refuge. And one of the things that came up over and over again is that victim survivors of family violence seeking relief in some way would be given referrals to community services that couldn't provide assistance. And they talked about how that led to a real despondency to be sent around on this wild goose chase to try and find services, all the time reinforcing that there wasn't a place for them, there wasn't a support for them. So the resources that we created as part of this project were ones where we really checked the eligibility criteria, made that really, really clear, and strength-based, really lifting up and acknowledging everything that temporary visa holders and new migrants are doing to support themselves as well, because they're so smart. So a lot of tenacity.
Yeah, fantastic, Julie. And that report will be included in the links available at the close of this webinar too, for anyone who's interested in reading it. And I'm sure there's a lot of content that will be of much interest to, and for good strategies and best practices too.
Yeah.
So I really recommend it to listeners to look at some of the materials we'll be actually publishing at the end of this webinar. Julie, lastly, as we come out of the pandemic, what do you think needs to happen to better support victim survivors generally and to prevent family violence?
So many, and I'm only going to mention a few because we've only got an hour in total.
Yes.
The lessons are that we need to be able to treat everyone in Australia with the same high level of respect and dignity. That's a major and important way of dealing with family violence. If we were able to give, and we are able to give, we choose not to provide temporary visa holders and new migrants with those supports, just think of the additional options they would have. We know that people don't leave violent relationships because of money. By just providing that safety net, you are providing additional options for them, as well as sending that positive message rather than a negative message. The other thing I would say that we need to start those respectful financial conversations and how to do them, and education around what that looks like early in primary school, because that is the way to change the attitudes and behaviours that cause the financial abuse, and that is the way to put a stop to it. And I think they're the main two, and I'll just leave it there because there's so much more to say, but I really want to hear from the other speakers.
Oh, thank you, Julie, so much. And turning to Adele, in your role at the Multicultural Centre for Women's Health, Julie's obviously flagged this as an issue, but we'd love to hear from you in terms of how COVID-19 impacted on migrant and refugee women's experience and family violence from your perspective.
Oh, thank you, Sally. And thanks, Julie. I think you've really set a great context there. So definitely everything that Julie has talked about, we have found has impacted negatively on migrant and refugee women during COVID. The thing that I would add, I suppose, is a couple of issues. One is about how difficult it is, even pre-COVID, for migrants to bring their families to Australia. So whereas, if you're born in Australia and you have your family here, they are usually a fantastic source of support for you when you do need support. So it might be, early parenting, you've just had a baby, your sister and your mum come to the birth. When you need a little bit of a break, they'll come and help you out. But that's just such a different experience for new migrants in Australia because it's so difficult to get your family to come out. Even so, the way that a lot of new parents deal with that is arrange for their parents to come immediately after the birth and provide that support. And that just wasn't possible during COVID. So we have a group of newly parenting women, very socially isolated, stuck at home, and no support, which I think is, obviously generative of lots of issues, mental health concerns in particular, but also family violence and the difficulty for women to actually get support, of course, in those situations. I think the other group that has come to our radar during COVID is older women, older migrant women. So there were some instances that we heard of family, younger families, so the generation before the older women having financial difficulties and moving back in with mum. And that, of course, creates not necessarily conditions for exploitation, but certainly that was some of the feedback that we heard, instances of elder abuse in those situations. And just an entitlement to mum's kind of resources and housing, and without really taking into account her rights. And of course, the supports that older women normally had outside of COVID, of their ethno-specific support groups like Italian clubs or Greek clubs, they just couldn't meet anymore. And this is also a group that really doesn't have much access to digital technology. So they were really left out and quite isolated. The groups, I think, that were not eligible for support, as Julie has mentioned, I'd also mention quite newly arrived women who weren't working in a workplace for a year and so weren't eligible for job seeker. So they would ordinarily be eligible for government benefits, but but they weren't because they hadn't been working in that particular workplace that was getting the job seeker on their, job keeper on their behalf, weren't eligible for that. So that a lot of people were experiencing extreme financial hardship.
Adele, there's an interesting point you were keen for me to raise. And was there an increased risk of reproductive coercion amongst migrant women during COVID-19 lockdowns?
Yeah, that is an interesting one, Sally. We don't actually know a lot about reproductive coercion. I think we're all just kind of wanting to do a little bit more research on that. But for all the reasons that I've mentioned already and the reasons that Julie has talked about, there has been an increased risk and increased incidence of reproductive coercion. Look, reproductive coercion can take many forms, and it is often incorporated into a pattern of family violence or sexual assault, and it can include perhaps removing condoms during sex or sabotaging contraceptive use by other means, or preventing or forcing an abortion. It is a form of interpersonal family violence or interpersonal violence, but I guess the thing that has also come to our attention is the way that reproductive coercion for migrant women can be supported through health system inequalities. So, for example, when it can be difficult for a woman to freely access a timely abortion. And one of the case studies that came up in some research that we did a couple of years ago now, so it was not in COVID conditions, but this is the kind of thing that would be exacerbated. A woman who got pregnant and did not want to have an abortion, but whose all this woman's interactions with the health system were mediated via family members and her husband. So her sister-in-law rang the abortion provider in the first place to make the appointment. And then when the husband went along with the woman and did all the interpreting, and the health service providers did not pick up that this woman did not want to have an abortion. So this was reproductive coercion, which was facilitated actually by inequalities in the health system. So I think that it's really important to have a look at the broader context of health inequality when we think about reproductive coercion for migrant women, all exacerbated during COVID.
Oh, absolutely. And in relation to such a shocking example, what should governments be doing and or investing in to address and prevent family violence in multicultural communities? Again, a broad question, but within the timeframes, what would you say, Adele? What would be on your wish list?
Yeah, look, I think in terms of reproductive coercion in particular, definitely decreasing inequality in the health system. That's gender inequality and racialised inequality. We need to operate on both fronts in terms of the health system and society in general. I think thinking about prevention, because that's really my main focus in the work that my organisation does in family violence. I think government, and this is evidence-based figures, government needs to invest at least 12% in prevention of the amount that is spent on response in order for prevention to be effective. So definitely a much bigger investment. It needs to be a long-term investment, and for migrant and refugee communities, it must be specifically targeted and tailored to be meaningful and delivered in languages that the community can understand. Investment must be directed towards changing systems and structures that impact on migrant women. So it's not enough to change kind of the way people think, but that is important. It's important to change attitudes, it's important to change behaviours, but equally important to really have a look at those systems and structures that oppress women. And I guess, looking at, for example, the care burden on women, one of the things that we know, this is pre-COVID numbers, but obviously would be more now, but women in particular, if they were paid for all the caring and housework that they did per year, they'd be getting an extra $40,000 in their pay packet. And for migrant women, it would be a little more because they do a little bit more of like a few hours per week additional caring. So I think that's something that if we can value the work that women do, it's currently unpaid, but we really need to value it and make sure that it's taken into account when we, have a look at our economy and what all of the different work that we do is valued, how that work is valued. Finally,
sorry, go on.
Oh, sorry, I just want to make just one more point, and I think when we're addressing prevention in multicultural communities, migrant women are really the ones who are leading the way. They're the ones that are going to be most affected by prevention efforts that work. They're going to benefit from that, and they're going to suffer really from prevention efforts that don't work. So I really think that we need to invest long-term into sustainable gendered violence prevention programs and into making sure that there's leadership of migrant women in those.
Yes, and harks back to those respectful financial relationships that Julie was referring to as well. It's thank you so much for that, Adele. Louise, turning to you, did the pandemic lockdowns last year present any challenges for specialist family violence support services when it came to continuing to offer a victim-centred approach?
Thanks, Sally. And just before I start, I do want to acknowledge that I live and am currently working on unceded Wurundjeri country, and I want to pay my respect to past, present and emerging elders. Yes, there were challenges presented by COVID, as I'm sure you know, was felt across all sectors and industries. We saw in the specialist family violence services space, we saw an increase in the demand for family violence services. And we saw an increase in the complexity of cases. So, for example, what it meant to assess and manage risk with victim survivors if their perpetrators were at home with them at that time. Victim survivors' options for accessing information and services were limited even more than they are in normal times. So we saw many people using trips to supermarkets and pharmacies as the time where they were then accessing information or contacting support services. And our sector really had to adapt to that. Specialist family violence services also consistently reported concerns about the lack of visibility for children or of children experiencing family violence during the lockdowns in particular. The online environment that many services adapted to has kind of created or limited the opportunities that services had to engage with children and young people, which they might otherwise have opportunities to in person. Something else we saw, which has been really interesting, was an increase in contact from third parties like family and friends reaching out to services about people that they cared about, who they were concerned about experiencing family violence. Services also experienced more contact from other professionals in allied sectors reaching out for secondary consultation around family violence. So for us, that really highlighted the need for more information and resources to support family and friends, and the importance of a shared whole of community and whole of systems approach to recognising and responding to family violence. And I guess the last and really significant point around COVID impacts was we saw the gendered impacts of COVID playing out for our specialist family violence workforce. So this is a workforce that is overwhelmingly women, and you know, the general shift that we saw during the pandemic back to traditional, I suppose, gendered norms and roles impacted on our workforce as well. So where women were taking on more caring responsibilities while still working from home, there was increased financial on households. Many professionals had to reduce their work hours to accommodate for caring for their children while learning from home. That impacted both on the community and victim survivors and on our workforce.
So with all those learnings over the last 12 months, what have you changed in the way you deliver your service as a result?
I guess one of the most important learnings, and it's not necessarily a change, but something we didn't have the language for before COVID, was that specialist family violence services are essential services, that you know, family violence practitioners are the first line of response, even during a pandemic, for assessing and managing family violence risk. The pandemic exacerbated existing challenges faced by the sector and created new ones. And some of those existing challenges
relating to workforce supply and retention and well-being, like I was mentioning earlier, became even more pressing over the last year. In particular, I mean, our services adapted and responded really quickly to the pandemic and started delivering online and remote services, everything from case management and counselling through to adapting the ways that we responded in crisis situations. We saw web chat supports across some of our services and other quick adaptations. This has had implications both for victim survivors and for the people working in the sector. While it did make some services more accessible for victim survivors, particularly in rural and regional areas, for example, those online adaptations and remote adaptations don't necessarily suit everyone and aren't necessarily accessible for everyone. The challenges for the sector and for the workforce included integrating online service delivery with existing case management systems, for example, and also for practitioners delivering specialist family violence services from home, what that meant in terms of having sensitive and confidential family violence conversations in the home when they were maybe also caring for children, or living with housemates or other family members, and what it meant for in terms of limitations around the supports that the workforce had access to around debriefing and supervision remotely. We also saw gaps within the service system response, which already existed, but we saw them tested as individual sectors that intersect with family violence reverted to more siloed responses. We're in the midst of really significant reforms all aimed at integrating the service response to family violence, and the pandemic had a significant impact on that. And we saw, as I mentioned earlier, that increase in secondary consultation, where sectors or professionals working in other human services were reaching out to family violence services for additional support. That wasn't met by increased resourcing and investment. So there's a long-term need for increased and sustainable resourcing for specialist family violence services, which is driven by ever-increasing demand, and it's only been exacerbated by the COVID-19 pandemic.
Well, thank you, Louise. And just finally, we heard from the Chief Justice in terms of the dynamic projects and initiatives that the Family Court is investing in. Is there anything else that you would like to add in relation to what you could see the justice system doing to uphold the safety of children and young people experiencing domestic violence?
Yeah, look, I think first and foremost, it's critical that the system recognises children and young people as victim survivors of family violence in their own right. We need to see tailored legal responses that reflect that. We know that children and young people are sometimes included in risk assessments, say when their parents who are victim survivors may have risk assessments through an applicant practitioner, for example. Recognising children and young people as victim survivors in their own right would mean conducting those risk assessments with children and young people. We've seen that happen in the Melbourne Children's Court, and would be really interested in looking at innovations that have happened in some courts and how those could be applied more consistently across the courts. There's other innovations such as safe spaces for children and young people, but in particular, I think that just acknowledging the limitations that lawyers have when in terms of responding to information about risk that they might have access to through instructions. The specialist family violence supports that are available to victim survivors through applicant practitioners and through other kinds of social work supports, it's really important that children and young people have access to that same level of support.
Oh, excellent. Thank you so much, Louise. Helen Matthews from Women's Legal Service Victoria. I know you've been working very closely with the court system and also obviously your clients. Did the COVID-19 lockdowns have any sort of positive effect on the justice system?
Look, there certainly were, Sally, some sort of anticipated improvements that were accelerated because of COVID. I think COVID sort of put an exaggerated lens on many things. Either some of the existing problems became sharper and more impactful, but some of those improvements that occurred, such as the remote hearings that have been mentioned already by the Chief Justice and others, really did make a huge difference. And I'm hopeful that his indication that there would be maybe a 30% retention of remote hearings is something that really does continue across the range of jurisdictions that we work in. So the benefit for remote hearings are really obvious for people living in regional areas. Anybody working in the family law space knows how difficult it is to manage matters through the circuit system. We also, for example, today have received a referral to somebody who's suffering, has suffered 30 years of family violence and is still going through the court process with a nice little systems abuse application by the former partner. That hearing is in a regional town which we would be unable to get to, but will be able to represent this person, provided that we're able to access it through remote hearing. So I think that there is an increased access to justice issue there. It also, the remote hearings gave us another option for managing safety. It created its own issues about how do you make sure that somebody is not unsafe in their own home participating in hearings, but it did give us another option, and options for women with children who might otherwise find it extremely difficult to be able to get to court on time and get home from court to manage the return of children after school and so on. I think another benefit of those remote hearings was increasing the pool of lawyers, for example, that would be available to women who are seeking legal representation. So it's not so place-based. I think that possibility of removing that postcode justice is really a great option. And the experience we had in the family court of the court being able to bring in judicial officers from other states to hear matters remotely, where the participants were in Melbourne or in Victoria, was really a great innovation which we'd like to hang on to. So that, you know, there are other benefits, but I think that remote hearing is the one that we really need to hang on to and make sure that we keep the best of that in our processes.
A lot of our parents, the logistics of actually picking up children from school to have appointments was eradicated, and that did make a big difference. What still needs to be done to improve victim survivor safety and perpetrator accountability in your view, Helen?
Look, I think there's a lot that still needs to be done, as was mentioned by Louise just before. The real attempt to have an integrated approach to responding to family violence is something that we're still working on. And I think as lawyers, we really still need to improve our capacity to work with others working in the family violence area. So recognising that sort of specialised assistance that somebody might get from a family violence worker is really going to benefit them throughout their family law proceedings, for example, or in the process of negotiating the trauma of going to a magistrate's court. So I think actually that integrated response and seeing where the legal and justice response fits in that is really something that we have to continue to work on to improve safety and really improve perpetrator accountability. So in the family law system, we see that we've got the Lighthouse Project. I'm very much hoping that risk assessment embedded in a family law proceedings does actually expand across the country beyond the 3 registries where it's happening now, and hopefully that increase in funding gets us there. That would be a great thing. But I still see that in the family law system, we have that tension which exists, I think, across all of the jurisdictions that are dealing with family violence a lot, that tension between due process or procedural fairness and safety. And one of the things that we would really like to see is that determination of the facts of family violence happen very early in those proceedings, which might otherwise take, even with improved systems that the Chief Justice is talking about, you still might find yourself in court for a long period of time before you would have the opportunity to have that evidence tested. So that simple fact of whether or not that family violence has occurred and is impacting the decision making, or should be impacting making the decision making about parenting arrangements, for example, deciding that family violence question early in the process would be a great thing to, in my view, improve safety, rather than court becoming a war of attrition where basically you sort of are making judgments about whether or not you can risk this level of loss of safety by actually bringing the matter to an end. So I think that's an issue in family law. In the magistrates court, where we have, which is a high volume court, where we've got quite a backlog in family violence intervention order matters being resolved, I think we have to be careful to make sure that the efficiencies that the court needs are not going to put safety at risk anywhere along the line. And another area that we work in where we find perpetrator accountability seems to not be high on the agenda is in the child protection, where clearly the focus is on responding to child safety, but it's often in a way of sort of having a better, rather punitive effect for the mother and children, because the perpetrator of that family violence is not really held to account. So it's the mother that's being held to account for the perpetrator of the family violence. So actually seeing some adjustment there, so there's a more consistent response that's recognising where the risk lies. The risk doesn't lie in the mum trying to do what she can to make her kids safe. The risk lies in actually making sure that perpetrator is prevented from putting that family at risk.
Yeah, and swift assessment of the evidence, as you said, perhaps by a judicial officer if necessary, if we're in the family court, would actually deal with some of those issues. So, yeah, I couldn't agree with you more, Helen. Finally, our work across the justice system is mainly about responding to violence after it has occurred. Is there a role for the legal and justice workforce in preventing gender-based violence, in your view?
Look, definitely, I think so, and our organisation strongly supports this. We've done some work around this in our Starts With Us project. So that's very much recognising that a major driver, or the major driver for family violence, is that gender inequity. And so how do we address gender inequity? And while, we work in the family violence space, which has a fair number of female practitioners, but still we're in a very hierarchical system necessarily, that the justice system is. And what are we doing to make sure that we are addressing gender equity issues within our own workforce? What are we doing to make sure that we recognise when people are trying to respond to client demands, and we may not be being supported by our senior practitioners in actually resisting requests for us to take steps which might be actually furthering systems abuse rather than ending systems abuse. So I think there's a lot within our workforce really asking people to sign up to the changes that are necessary, and those changes that have been signalled by recent government inquiries about sexual harassment and the judiciary, recent exposures in our sort of parliaments and so on, to make sure that we are, as a workforce, ensuring that gender equity is a thing of the past in the legal and justice sector.
Well, I can't believe we've actually hit 1:59 p.m. I want to thank all the panellists for their insights, their call for positive arms, for strength, and I want to thank you for all your time and participation, including everyone who's actually listened today. The insights into domestic violence and the potential reform in the new COVID normal is a challenge to us all. I want to thank all of you who have actually joined us for this important discussion. While we have seen that there are key indicators of domestic violence, it is important to note that domestic violence can take many forms. Today's discussion has also revealed that everyone involved in the response to family violence shares a common understanding of the importance of raising awareness and education in this area. In line with this, it is a duty and responsibility of all of us to instigate social, cultural and systemic change in this area, and to continue our work in supporting victim survivors. It has been a privilege to moderate this discussion and support the community effort to protect those who have been or continue to be subject to domestic violence. If listening to this webinar has raised personal issues for you regarding domestic or other types of violence and you require assistance, help is available. If you are at immediate risk of domestic or family violence, call the police on 000. Other support can be found by contacting organisations which include the Women's Information Referral Exchange, Domestic Violence Victoria, Multicultural Centre for Women's Health, the Women's Legal Service of Victoria, Victorian Legal Aid, 1800 Respect and Safe Steps. We also will have some additional links to assistance and to other articles that we've mentioned throughout this webinar. I wish you all a good day and thank you very much again for your time.